cause numbers 24 DCCR 1374, 1905, 1906, and 1907.
And Judge, I brought something. Judge, this has been the one with the federal issues, and we had a proper meeting with the feds in early September, late August, for a day. I had informed them that this needed to be wrapped up because of what you had expressed to me in our last meeting. They have followed up with me and said that charges are imminent. And Judge, just to be very straight with you about it, they had told me that in June. And then I'd said, I'm getting heat respectfully from the courts, and she has charges also pending in chambers in Hardin County. The courts are aware of what's going on. Mr. Moran, the assistant U.S. attorney, has informed me that he thinks it's going to happen either, he alluded to me it's going to be in October, but I have no way of telling the court with absolute certainty that's correct. So I don't have any control over it because I thought it would be sooner.
Right.
But the dilemma for me is, and Mr. Smith, who's been super helpful and accommodating dealing with this issue, is that you know that the federal charges are coming. They haven't landed yet. But I don't want to be placed in a situation where I have no plea. State charges and federal charges are coming. That's why I brought that email.
I appreciate the email. If you don't mind, I'm going to hang on to this.
Absolutely.
I might give Ray a quick email or a call just to find. I've known him we used to work together, so I'm fine with it.
I've spoken with him. I've sent him all of the restitution amounts for our cases.
Yeah, and he may be waiting on other.
We had like a 6-hour proper meeting with the U.S. Attorney's Office. We have nothing else to give them.
Right.
We give them everything and each thing. It's really just waiting for. He's claiming a debriefing, and the charge is coming, but it's taking.
Okay.
Quite time.
I'm going to do. Let's do 45 days. Reset, and then I'll email him or give him a call and just see if he can. If maybe that helps, or at least I can find out if it's that they're waiting on maybe other agencies that y'all don't have any, or you don't have any access to, if there's other counties involved.
In the first email that's on there, you might notice that I was getting heat from Jefferson County, parentheses, Judge West.
No, I saw, I saw that. No, I'll give him a call and see if I can get some more information, and then we'll hopefully get some answer between now and then.
If I know anything, I'll call him for it.
Okay, thank you. All right, you're free to go. 45 days. Thank you, Mr. Rennick. Mr. Wilson, Mr. Wilkerson, Mr. Cole, Mr. Adams. See, Mr. Cole, you have Leonard Idlebird.
Yes, sir. Yes, sir.
Been here last week and flagged this.
Oh, that's okay. I think it might help just to others to know what's going on too. Would you put a sticky on that and then put it on my desk just to remind me to do something with it, please, ma'am? Good morning, Mr. Cole.
Good morning, y'all.
Good. Good morning, sir. Are you Leonard Idlebird?
Yes.
This is cause number 16-25968. It's the MTRP. I feel like we're waiting on, there was a motion for a competency evaluation,
Yes, ma'am. He filed the
but I don't see that it's been done yet.
it's been done.
It has, we just
Yes.
don't have a report yet.
It should have been e-filed into the case, Your Honor.
The report?
Yes, Your
They
Honor.
sent it to you?
Yes, Your Honor.
Oh.
To me, not to you.
Oh,
I mean,
okay.
I certainly take
Who
Mr.
did
Cole's
it?
word for it. but-
Dr. Riggins out of Houston.
Oh,
The court wouldn't pay for his evaluation.
I don't see that it's in here yet.
I do have a copy of it.
Can I see it real quick?
I'll have to send it to your email, Your Honor.
Oh, okay.
Yes.
All this paperless stuff.
Yes, Your Honor.
Finding competent, not competent?
Not competent.
Okay.
Not competent or
Dementia.
dementia?
Dementia.
Because I think there's a legal difference.
Yes.
Yes.
Yes, it was dementia.
Okay. obviously, we need to take a look at that. I'm going to reset it 2 weeks.
That sounds great.
If you will make sure, it should, if you e-filed it, it should be coming through, but if you'll also just in an email forward that report to Ms. Malfino and
Yes.
and that way you guys can take a look at it, talk and see if there's something that you can work out. I can look at what my options are with regard to that diagnosis, and then we'll see where we are in 2 weeks.
And Judge, just so the court is aware, I spoke at length with his probation officer, Ms. Hunter, last week. Previously, when we were here, I believe back in June, you ordered that he not drive, and you spoke with his wife here in court.
Yeah.
Ms. Hunter relays that he is complying with all that. She
Okay.
actually comes to his appointments
Good.
with him, and that everything seems to be
Okay.
going well with respect to that condition.
Okay, well, maybe we'll be able to work it out with just modified type probation. We'll see. Okay, all right, we'll see you in a couple of weeks. Mr. Gertz, you've got David Hatcher. Morning.
Judge, how are you?
Good. How about you?
Well, I'm good. Excited about this week.
Oh, me
Aren't you
too.
excited?
I'm so excited.
I can see it all over your face.
Yeah. Good morning, you're David Hatcher.
Yes, ma'am.
And this is 24 DCCR 2470. I have a memo that this was the last reset for an announcement.
There's a rejection I just forwarded on, Your Honor.
Oh,
And it's pretty non-specific. Any offer that was going to be made is going to be a pen time offer.
okay. Let me get that.
We were
pulled up.
looking for something vastly different than that, so.
All right, so
Page.
you're David Hatcher.
Yes, ma'am.
And Mr. Hatcher, you're charged with a third-degree felony offense of intoxication assault with a vehicle causing serious bodily injury from September 24th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment could be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have a plea bargain rejection that you've signed with Mr. Gertz that just shows that any offer the state would make would be for prison time and not for a probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Right? Anything that you guys are waiting on discovery-wise?
Nothing I know of.
Notice how the attorney is walking a fine line. Here, federal charges are imminent, but not yet filed. This is a classic example of pre-indictment strategy, where timing can drastically affect plea negotiations. What would you do if you were in the client's shoes knowing charges are looming, but not official?
I'm not aware of anything discovery-wise, Judge.
All right, we will get it set on the next available trial docket. Stay in touch with Mr. Gertz. He'll let you know when you need to be back. Thank you. You're free to go. See, Mr. Lewis, you have Naquindon. Oh,
He's right here.
oh, there you are. Naquindon Acleese.
Yes, Judge.
Good morning. You're Naquindon Acleese.
Judge, you're going to ask me this in sentence, I'm going to explain now. The reason it's now a probation offer instead of the pen time offer, which originally was based on his criminal history, because he had done a 10-year stretch for robbery, starting in 2014. Really, I'm rewarding him because he's tested clean every time since about this time last year, Your Honor. And he's come to court. He's done what the court's asked him to do as far as trying to hire an attorney. I think he ended up still having Mr. Lewis appointed, but I know that he's done everything the court's asked him. Essentially, I'm rewarding him because he's tested clean ever since September of last year.
Okay, thank you. I need your signature. And are we going on count one only?
Yes, Your Honor.
Okay, you're Naquinda Niclease,
Yes, ma'am.
and will he waive the formal reading of the indictment?
He does, Judge.
Mr. Niclease, in cause number 24, DCCR 0478, the state has elected to proceed on count 1 only. It alleges you committed the second-degree felony offense of burglary of a habitation from February 5th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Niclease is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Obviously, you've been doing very well and following all of those bond conditions. Continue to do that. You shouldn't have any issues. And then we'll see you back at sentencing. You need to stop on your way out of the courtroom today and talk to probation, and she's at that desk right there. Okay? We'll see you back.
Thank you, Your Honor.
Thank you. Mr. Lewis, you have Karis Antwine.
Yes, ma'am, Judge.
Good morning. Are you Karis Antwine?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Judge.
And I'm guessing there's a warrant for what?
His bondsman surrendered his bond.
Okay.
And honestly, we thought it was something that was taken care of. They had contacted me. I actually got in touch with Mr. Antoine. He spoke with him, but
Okay.
Yes, because I talked to him Friday, and
Okay. That's good. I just wanted to make sure. You're good. Okay. And he'll waive the formal reading of the indictment.
he does, Judge.
Mr. Antwine, in cause number 24, DCCR 1878, you're charged with the third-degree felony offense of injury to a child from September 26th of 2023. And how do you plead to that charge?
okay, good.
You either did it or you didn't do it. Guilty or not guilty? Are you pleading guilty freely and voluntarily? And because you did what they charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Here's a critical legal nuance the court distinguishes between being not competent and having dementia. Competency determines if a defendant can stand trial, while dementia is a medical condition. Both can change the course of the case dramatically.
And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Antwine is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report, and that'll give me more information about you and your case, and then we'll come back later for sentencing. So, with regard to a bond based on the nature of the plea agreement, Mr. Nichols,
I don't have any objection to that, Judge. He has no felony history that I see.
Right. Let me look at this affidavit real quick.
The charge itself is for hitting a child with a belt, over discipline, essentially.
Okay. What's the status of that relationship? Do you still live with that child?
I haven't been around him since the case went on. When
Okay.
I do see him, I see him with my mom.
Supervision.
Her mom.
Okay.
And I really miss my family.
Well, and we'll see how that goes on probation. For now, you're still under that order to have it only supervised, okay?
I understand.
And then you can work up, once you're on probation, hopefully to doing the right classes and everything, and that should be lifted. What I'm going to do, Mr. Antoine, is reduce your bond in your case to $1,000, and I'm going to make that a personal bond. So I think that means, though, that he still has to go. Right, okay. So you're still going to have to go, but as soon as you get to the jail and they process you, you're going to be released without making that bond that I set because of the bondsman getting off your bond. Okay, makes sense? It's just, but here's the thing. I'm kind of putting myself out there to make sure that you're going to do all the right things between now and sentencing, okay? You have been until then, but it looks like you had some issues at some point communicating with your bondsman. It's very important, several things that you have to do between now and when you come back for sentencing.
I got you.
Once you're released from jail, you're going to get some paperwork today. It's going to have where probation is. You have to go straight to the probation department, okay? If you get released for some reason later this afternoon and it's too late, then you go first thing tomorrow morning. If you don't do that and get that process started for that pre-sentence report, I don't have to accept this plea agreement. So things could be a whole lot worse. Do you understand? If you violate your bond condition and you're around the children or child that you're not supposed to be unsupervised, then obviously I don't have to accept this. Things could be worse. So keep following all of the rules of your bond. Yes.
I have one question. Okay, is it only for that child?
No, I would say at this point, it needs to be all of your children, and then we'll deal with everything when we come back for sentencing, okay? And so that's for everyone, just to make everybody, well, it's not for everybody, it's for me to feel more comfortable until I get the pre-sentence report and I see what all is going on, how many kids you have, where they live, what the situation is, what the recommendations are from probation. So we're only talking about 5 or 6 more weeks.
Yes, ma'am.
But it is,
I really have something important to tell you.
what?
I've been raising my 10-month-old for months by himself. So if I have to give him up, I will, because I need to start thinking for my kids.
Well,
He's a baby. He's been with me since 12. Like,
where's the mom?
we don't talk. Since the case going on, we don't talk like that. Like my mom and her mom, that's when we meet up. But
I think the court's question is the mother of the 10-month-old the mother of the child in this case?
yes,
So where's the child that was in this case live?
she's with her mom. I don't see them like that. Like we've been separated since I had been arrested, and she stayed with her mom, and I have my own place.
Okay. But it's the same mother of both of your children?
Yes, ma'am.
But the baby lives with you,
Yes, ma'am.
and the other child lives with her?
Yes. She got 4 other kids live with her. I just got one.
Pay attention, Hatcher is rejecting a plea deal that could have included lighter sentences going to trial on a third-degree felony carries serious risk up to 10 years in prison. This is high-stakes decision. Making in real time, could you make the call under that pressure?
Did you go through anything with CPS as far as they were, I mean, we have an order for some CPS records, but was there anything to CPS get involved?
No, ma'am, I never went through nothing like that.
Okay.
I don't think anything's been provided to us in response to that order.
It doesn't
Judge,
look
so
like it. So maybe that's because there wasn't anything.
I think it was important that I tell you that I have.
No. I would much rather you be honest. But and if you're raising, let me look at something real quick.
No, not at all.
Yes, Judge, and just to clarify, the child is, in this case, not his biological child.
Okay. So how many biological children do you have?
3.
No, with her.
Oh, 1.
Just
One with that. Where are you, and then the other 2, or where are they?
They're all with her, and all my other 2, they're with their moms.
With their moms.
Yes, ma'am.
So this is the only one you have. So there's no big deal. I mean, obviously, you love your stepchildren, but that this isn't your own biological child that's the
Right.
subject of this case.
right.
Okay. Then what I'm going to do as a condition of your bond is order that you not have unsupervised contact with all of the children except the one that you're raising. Okay. If you're raising that child, I'll allow you to continue to do that. You'll get out, make sure that you follow all of those bond conditions. The last thing I was going to tell you is that as a condition of this, if you are arrested for anything between now and when you come back for sentencing, again, I don't have to accept this agreement. Things could be worse. You understand? Okay, we'll see you back at sentencing.
Thank you, Your Honor.
Thanks, Judge.
Thank you. It's no contact without supervision except for the 10-month-old. Mr. Lewis, you have a sentencing with Shay Brooks.
Yes, ma'am.
Sentencing. Good morning. Are you Shay Brooks?
One shot.
Shy. And Mr. Brooks, in cause number 24, DCCR 2034, was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle, received the pre-sentence report. Has everyone had an opportunity to review the report?
Good.
State has Judge.
Any additions or corrections?
Nothing, Judge.
Nothing to state, Judge. We just ask the court probably reading the card.
Thank you, sir. All right, Mr. Brooks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you to a term of 10 years in prison, but probate that for a term of 10 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have the felony conviction. Well, no, it's not. I'm sorry. You do have, for all practical purposes, your case here in court is over if you do everything you're supposed to. And you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence that you've already agreed to. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal.
Yes, ma'am.
I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
This is a classic example of the court rewarding consistent compliance. Even with a serious criminal history, the defendant is offered probation because he's been clean and followed court orders. Small steps like this can have a huge impact on sentencing outcomes.
Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm.
Yes, ma'am.
If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you.
Notice how plea agreements are structured. By pleading guilty or no contest, defendants often give up the right to appeal, and probation terms are clearly outlined. This is the moment where legal strategy and personal choice intersect. Here's an interesting procedural move. The judge reduces the bond to $1,000 and makes it personal. This isn't just a number, it reflects trust and the expectation of compliance before sentencing. It's a tactical balance between risk management and fairness.